Hello and welcome to the 23rd episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we're joined by a special guest, Professor Mary Graw Leary of the Catholic University of America Columbus School of Law, to break down Section 230 of the Communications Decency Act, the 1996 federal law that has shaped much of the modern internet. Professor, thank you so much for coming on the podcast.
Great to be with you.
Let's get right into it. In order to understand Section 230 of the Communications Decency Act, we first have to understand the act itself. What was the CDA, and what was happening in the 1990s that led Congress to pass it?
Sure. The 1990s are almost quaint to think about now. But in that time, the United States Congress had started to look at the Telecommunications Act. Specifically, they needed to update the 1934 Communications Act. A lot had happened since 1934, as you can imagine, and they had to adapt to things like cable television, digital communication, and this new thing that was emerging called the internet. And so, in their preparation for updating the communications law that would include this new medium, some of the Senate were concerned that the protections that had been in the broadcast world, protecting children and families from explicit content, for example, as well as protecting children from unauthorized adult interaction with them, wouldn't translate to the internet. So the Communications Decency Act came out of the United States Senate as an effort to have the law updated to reflect those protections from obscenity, from harmful material, and from dangerous individuals that were already in existence in the broadcast fora.
That's a great explanation, and today we're focusing on one section of the Communications Decency Act, Section 230. Could you explain what that section is?
Sure. It's a little bit complicated, but I think the first thing to remember is it's Section 230 of the Communications Decency Act. And the title itself is Protection for Private Blocking and Screening of Offensive Material. I always like to point that out because we need to see that this statute really emerged from a landscape of child protection. So you had the Communications Decency Act on the Senate side, but you also had some concerns on the House side about another issue as it related to the internet, and that was wanting to encourage these new platforms. And remember, Google hadn't been invented, social media didn't exist. They were still talking about dial-up internet and bulletin boards, if you can imagine that. But there was a concern based on a case called Stratton Oakmont, which had come out of a state court in New York, that had found a platform liable for information that a third party had put on its bulletin board. And so some members of the House were concerned that the law should encourage these platforms to take down information and to not have them be held liable when they took down something and the author of that information was angry about it. And so they put forward their own legislative proposal. And when the House version and the Senate version went into committee, Section 230 of the Communications Decency Act emerged. And this section lies within the Communications Decency Act, and it does exactly what the title suggests. It provides protection for platforms, for Good Samaritans who are blocking or taking down information that they feel is not appropriate for their platform. Now, there's also some language in Section 230 that talks about a platform should not be treated like a publisher. And what they're trying to get at there is, in the physical world, a newspaper is responsible for the content on its platform because it generated it. But Congress recognized that these future platforms would be hosting third-party generated information. And so, as Justice Thomas has pointed out several times, yes, there was a desire that these platforms not be treated as a publisher responsible for everything on their website as though they had created it. But they still the text would suggest, should be treated as a distributor. So they weren't scot-free, but they weren't as responsible for third-party content as they would be for their own content. So that's what Section 30 emerged as, a compromise within the Communications Decency Act as part of the new Telecommunications Act in order to protect children primarily and families, but also to incentivize platforms to take down this kind of material and to encourage platforms and other experts to develop technologies that would further screen and block this kind of material.
The original purpose sounds really great, like the internet needed it. And as you said, this law was written in 1996, almost 30 years ago. And the internet today looks nothing like the internet Congress was dealing with at the time. It's miles different. And that's a huge reason why there's now so much debate over Section 230. On one side, defenders, like many major tech companies, argue that this broad immunity is necessary for free speech and the modern internet to function. What exactly are the defenders of Section 230 advocating for? Do they want to keep it? Do they want to reform it?
No. So, a couple of sort of framing principles I think would be helpful here. Those who love Section 230 are primarily these tech companies, which, as we all know now, are the most wealthy companies in the world and arguably the most powerful companies in the world. These major platforms clocked in about $400 billion. I think that was just either Meta or Google last year. So they're massively powerful companies. And part of the reason some of us would argue they've been massively powerful is Section 230. Because think about what it does. It does what it does today, not what it was intended to do. You used a word, immunity, and it's totally fine that you used it. Lots of courts' opinions have used it. Immunity is nowhere in Section 230 of the Communications Decency Act, but they have gone into the courtrooms across America and they have transformed what was designed to be this very narrow protection for Good Samaritans and put it on its head and argued successfully that what it really provides them is something I refer to as de facto absolute immunity. And by that, what I mean is a very broad immunity for almost any decision they make. That's not reflected in the legislative history or the content or the text of the legislation. But by making that argument, they do claim First Amendment rights, not a part of a real concern of Section 230, and they also claim they need it for the internet to survive. And I'm a little bit snarky about that claim because, well, it may have been true in 1996 with this fledgling new industry that being free from some government regulation made sense so that it could find its footing. The idea that now it is needed for the internet to function seems quite frankly absurd. And I think it's also important to note, unlike any other industry, they have created a regime in which they cannot be sued effectively for many of their business decisions. And so as a result, they have no incentive to be safe. They have no incentive to do anything that is proper, but every incentive to do whatever they want because they will face no liability as long as Section 230 is interpreted in this broad manner. Could I say one other thing that I think is important? These arguments that the internet will break, they have made at the time at the time the Communications Decency Act was proposed, and the very few times that things have touched on their immunity. There's a bill called Sesta Fosta. They told us the internet would fall apart then. It didn't. There was a bill that changed federal law regarding online sex trafficking. They told us it would break the internet and free speech. It didn't. This is a constant chorus of them that they make that unfortunately, or I suppose fortunately, is really more alarmist than based in reality.
And you bring up this idea that this original purpose of Section 230 has since been distorted. And I want to go into sort of the process of how it got distorted from its original purpose. So going more into the judiciary, one of the most foundational cases in Section 230 history is Zeron v. America Online, Inc. First, what was this case about?
This case was actually a sad case. It was a defamation case. And I should point out that Stratton Oakmont, that New York case, was a defamation case. So very much people were concerned with these platforms being sued for defamation, but they didn't control the information that was put on their platforms. That was definitely a concern. And the plaintiff in that case was suing AOL, which was at the time a very big platform. It's hard to imagine because he had been the subject of defamation. There had been this terrible prank online suggesting that he supported the Oklahoma City bombing, if I'm not mistaken, which he did not. And he had contacted AOL numerous times and said, please take this down, and they wouldn't take it down. So he sued them with a number of claims, but one of them was that I told you this wasn't true, and I was harmed by your delay in taking it down. And in that particular case, this, as you quite rightly point out, the first or an extremely early case, courts weren't really sure what Section 230 was. AOL came in with this claim of broad immunity, and the court accepted it. It focused on the purpose of Section 230. Now, there are 5 policy statements in the original statute. 3 of them have to deal with protection of children, et cetera, but 2 of them do have to deal with the freedom of the internet and wanting the internet to succeed free of government intervention. And in this defamation case, where children were not at issue, it did focus on those 2 reasons, but it did have some very broad language in the opinion that might have been appropriate for that defamation case. It may or may not have been, but it certainly had nothing to do with the things that we see today on the internet with online sex trafficking, narcotics trafficking, exposure to child sexual abuse material, etc. But you're quite right. That was a foundational case with broad language, and it sort of started the ball rolling from there.
Exactly. And I want to get into this broad language a little bit more. Reading directly from the Fourth Circuit's opinion in Zeron, the court said Section 230 was enacted in part to maintain the robust nature of internet communication and accordingly to keep government interference in the medium to a minimum. By itself, that doesn't sound particularly controversial, but how has that language since been interpreted? And why do you believe it's become so consequential?
Sure. So what happened next was tech um, captured that language, sort of pulled it from its moorings, both the statutory basis for that as well as the legislative history of the statute. And it put forward that as the law. And frankly, a lot of courts then just started accepting it. But what we've noticed in the last 5 years or so is a number of courts have actually gone back to the text, have looked at what the internet looks like and said, wait a second, this is really not what was intended. Most notably among them is Justice Thomas on the United States Supreme Court, recently joined by Justice Gorsuch, in pointing out that that is Justice Thomas says a far cry of what was originally intended in this legislation. And you asked how this happened. I used to have my own theories, but a couple years ago, Chief Judge Mady made a great observation in a very terrible case called Anderson, in which he said, from the very start, courts held that Section 230 did much more than overrule Stratton Oakmont's publisher liability theory. Though Zeron has been criticized as inconsistent with the text, context, and purpose of Section 230, the opinion was cut and paste copied by courts across the country in the first few years after the statute arrived. And I think that's probably the best description of how this happened, unfortunately.
And precedent is so important in these court cases as courts rely on looking back on past cases, how they ruled to then rule on future cases. And there's another case I want to discuss here, Doe v. Web Group Czech Republic, which focused on child sexual abuse material, or CSAM. In that case, the plaintiff alleged that the defendant knowingly received and possessed videos depicting her sexual exploitation as a child. Yet the court still granted this Section 230 immunity to claims based on the receipt of that material. Could you break down that ruling and explain why you believe it was such a important interpretation of Section 230?
I can. And I think that it's important because it shows just how extreme these court interpretations have been, how far they have been pulled from the original text. What Justice Thomas refers to as, literally, this is the quote, a get out of jail free card. And this particular case, I want to make a couple other points about Section 230. One is, we've talked about the publisher liability, so that language is definitely there, that a website should not be treated as a publisher. Many judges feel that all that means is not a publisher, but still potentially a distributor. But a lot of courts have not interpreted it that way. Justice Thomas believes it should be interpreted that way. But also, there's a list of what we call carve-outs from Section 230. So laws that a defendant platform could not claim a Section 230 defense. One of them, not surprisingly, is federal criminal law. So it says Section 230 is definitely not designed in order to insulate a platform from a violation of federal criminal law. This holding literally said that the act of receiving child sexual abuse material, an act which I'd like to point out is a federal criminal offense, receipt of child pornography or child sexual abuse material, and possession of CSAM. This court described that as, quote unquote, an action of a publisher. And therefore, it gave this platform, which had knowingly received child sexual abuse material, as you point out, from a child victim of sex trafficking, had been informed, hey, I'm a victim of sex trafficking. Those images are of child sexual abuse material. The court said they were immune from a lawsuit. And that is so far from what was intended by this law, so far from the text, and actually much worse than Congress ever anticipated.
It was definitely a tragic ruling and a huge misinterpretation of Section 230. And do you believe that rulings like this can be traced back to how the courts ruled in Zuran v. America Online?
Think that that's one of the tracings, because of course, as you pointed out, precedent is so important in the law. And when you're dealing with early years, right, you've got courts who aren't technology experts, who didn't really appreciate what I think is in the public knowledge a little bit more now about how concerning some of the material is on the internet or these social media sites, etc. And so they would look to precedent, and they'd see this broad statement, and they'd see courts going on with it, and they would unfortunately perhaps not take that extra step of going back to the original text, going back to the legislative history, understanding the purpose. I do think that that played a role in this. But I think it's important to note that, as I've alluded to with Justice Thomas, but a growing chorus of courts have been raising questions about this. But to your point, some of these questions have been raised in the context of, we need to revisit our precedent, because yes, we need to follow precedent in our circuit, but it's been influenced by Zuran, and that is a problem. Or we need to go back to the original text here. So it's interesting how some judges have been raising this issue, but feeling as though their hands are a little bit tied now because they have precedent in their particular jurisdiction.
It's really unfortunate how it's been interpreted now. So I think we can assume the answer to this, but do you believe that Section 230 has failed to accomplish its original purpose?
I don't think there's any question. I think there's absolutely no question. So it absolutely failed to accomplish its purpose. And I've spent a lot of time going through all the legislative history on this statute. And when you see what the senators were expressing their concerns were, they could not imagine where we are today. And if I could just give you just a few statistics to give you a sense of what we're talking about. The National Center for Missing and Exploited Children, they are the sort of 911 of the internet. And they started tracking reports to them in 1998. And that year, they had about 4,500 reports of suspected child exploitation online. So that could be anything. It could be luring, it could be CSAM, it could be something else. Okay, lots of things. And it's suspected. These are just the calls into 911, if you will. In 2024, they had 29.2 million calls. That works out to around 10,000 a day. That means in the time that you and I are talking, or your listeners are listening to this podcast, hundreds of calls will come in to the National Center for Missing and Exploited Children. Currently, there are 62.9 million videos or images being housed by the National Center. These are all the illegal CSAM and other material that's been collected over time. Just last year, if we think about online luring, there were 546,000 complaints of online enticement, an increase of almost 200%. So I don't think there can be any question that the purpose of Section 230 has not been achieved. And in fact, it has encouraged these platforms to behave in a lawless manner because there is no ability to rein them in. And it's actually made things worse.
Those statistics were shocking to hear. I had no idea it was really gotten to that point. So, given that Section 230 has been broadly misinterpreted and is currently no longer serving its original purpose, what reforms do you believe are necessary to bring Section 230 back to its original purpose, or can it even be reformed at this point?
Well, I think the answer is Section 230 almost entirely has to be repealed. And there's several reasons for that. One is it's out of date, even if it ever did work, right? Like in 1996, the number one song was the Macarena. Like I told you, there was no social media. There were, most of America was still on dial up internet. Like it's just, you can't solve 21st century problems with a 20th century technology law. So that's the first reason. But the second reason, as we've discussed, is it hasn't achieved its goal. It's actually made things worse. And the other idea that the internet needs protection, that might have been true in 1996. It's certainly not true today. And I think we can see that if we were to just look at the inauguration of our last presidential election. Behind the winning candidate were all the tech leaders of all the major tech companies. As I said, they are multiple billion-dollar companies. So the idea that they still need protection now to grow is really ridiculous. But you'll note that I said it should almost entirely be repealed. It shouldn't entirely be repealed. The whole language about publisher, that should go. There's no need for it anymore, etc. But the idea that we have protection for good Samaritans, that we do create an incentive structure that a platform sees material and they think it could be problematic, that they are able to take that down and not be sued by the person who put it up, I think is still a very important aspect. And that would get us to what we intended, which was a system that incentivized protection of children and deterred dangerous decisions. What we currently have now is every incentive to do dangerous things because you'll make a lot more money and no incentive to be a little bit more cautious and protect children.
I agree. And I really think it comes down to the fact that 30 years ago, the internet just looked nothing like it is today. It's like you said, you can't rely on an old playbook when we're dealing with all these new issues that are coming up. So, for my final question for you, if you had to leave the everyday American with one reason why they should care about Section 230, what would you say?
Well, I am a law professor, so my answer might be a little bit more long-winded than you would like, but I really want them first to leave with an image. I had the good fortune or unfortune, I don't know how you want to put it, of testifying in front of the Senate Judiciary Committee last month on these issues. And I was seated between two amazing women. To my right was a woman named Joan Bogard. She lost her child to something on TikTok called the Blackout Challenge. This is a challenge that floats around on TikTok. I won't bother describing it, but it encourages middle school children to do something very dangerous, and it has killed many, many children. To my left was a woman named Bridget Noring, who lost her child to a purchase he had done online for medication on, I believe it was Snap. I could be wrong on that. Turned out to be fentanyl, and she lost him. Two really big problems on the internet. Behind us was a room full of parents with photos of their children who had died for things like this, or for trafficking, or for CSAM, or for sextortion on the internet. These are the problems, and I would like your listeners to understand these are real, these are growing. Tech, and the reason for it is not just that tech looks the other way, but Section 230 incentivizes them to look the other way. So 230 is the core to so many of the problems that we see on the internet. And the second thing I'd love your listeners to just keep in mind is they may be asking, well, gosh, why doesn't anyone change it? And I will tell you that the Senate Judiciary Committee has put forward numerous legislative efforts in a very bipartisan way to protect children online. It's really quite remarkable in today's climate how they have really worked together almost unanimously in several bills. But those bills never seem to get called on to a vote in the House of Representatives. And there's been a lot of study about why that is, a lot of press coverage, and the Tech Oversight Project is a great resource for your listeners. But essentially, there's one reason for that from where I sit, and it's money. Tech has spent millions preventing any reasonable adjustment to Section 230. And I encourage you to go to the Tech Oversight Project and to look at it, but I'll leave you with one statistic. By their calculation, just last quarter alone, the six largest tech companies spent so much money on lobbying that there was one lobbyist for every 6 members of Congress. And that worked out to something like $300,000 per day that Congress was in session. That's the kind of money that these families who are mourning their lost children are up against. So if listeners care about this issue, making sure your representative knows that you are aware of this issue and you expect change, I think is the only thing that will help overcome the real power that has been well documented the tech industry has in Washington.
It's a great message, and the internet does affect all of us. We all use it every day, so really we all should care about this. So that concludes the questions I have for you today. Thank you, Professor Graw Leary, for joining me today and breaking down Section 230 of the CDA and talking about why it might need to be repealed. It was a great conversation, and I really appreciate your insights.
It was great to be with you.
If you like this episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. You can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wahl on Law.